Thank you. We do have a quorum. I appreciate folks coming today. Senate File 2681 is the only item on the agenda today. Senator Seeberger is going to be presenting that bill. There is an A14. Nick Wonka, you want to come on up? That would be great. There's we're waiting for our fiscal analyst, Mr. Raymond, to come down. So when he comes down, we'll move the A14, which needs to be, but you all can start your testifying presentation.
Thank you, Mr. Chair.
Nice to see you, Senator.
It is my pleasure to be here. I don't have the opportunity very frequently to present before your committee, so I am very glad to be here this morning.
Well, where's our can of corn or our donuts if you don't ever get the chance to come in front of us?
They're on their way, Mr. Chair.
Thank you.
I am here to present Senate File 2689, which is the Medical Assistance Protection Act. The goal of this bipartisan bill is to protect a popular and important program that 1 in 4 Minnesotans rely on for health care coverage. Nearly 600,000, or 42% of MA enrollees, are children, including my youngest son. Many parents, pregnant people, elders, and people with disabilities also rely on medical assistance. This bill has been heard in 4 committees so far and has been amended along the way. For example, earlier this session, the State and Local Government Committee passed this bill with an amendment to allocate $1.23 million to fund staffing increases. This provision will be included in the State and Local Government Committee's omnibus bill. 2 amendments were approved in the Judiciary Committee. The first was at the request of the Sentencing Guidelines Commission. This amendment added an intermediate penalty level for low-dollar offenses. The second amendment narrowed the proposed new subpoena powers to exclusively cover Medicaid fraud investigations. And the last amendment's updated language in Section 3 to clarify that those charged must have the intent to defraud. This bill was heard in Health and Human Services Committee and passed without amendments. With the amendments, this bill will improve the Attorney General's ability to investigate and prosecute fraudsters by 1, adding 18 new staff members to the Attorney General's Medicaid Fraud Control Unit to account for recent increases to the state Medicaid budget. The bill will increase the MFCU staff from 32 to 50 people. That includes adding 11 investigators, 3 attorneys, and 4 support staff to the unit. 2, increasing criminal penalties for people who commit high-dollar medical assistance fraud. 3, following feedback from members and stakeholders, we incorporated language that requires that the Attorney General's office prove specific intent to defraud. This helps ensure that providers who make honest mistakes aren't needlessly criminalized. 4, after feedback from the Minnesota Sentencing Guidelines Commission, we amended the bill to incorporate an intermediate penalty that addresses lower dollar fraud offenses. And 5, giving the Attorney General's office the same authority that other investigating agencies have to subpoena financial records during criminal medical assistance fraud investigations while further restricting the power to only Medicaid fraud investigations. With me here today from the AG's office to walk us through the bill and answer your questions is Mr. Nicholas Wonka, Unit Director of the Medicaid Fraud Control Unit.
Mr. Wonka, welcome to Human Services.
All right, thank you. Good morning. Thank you for having us today. I'm Nick Wonka. I'm the Director of the Medicaid Fraud Unit, and I'm here to testify today in support of this bill, which would help ensure that we in Minnesota continue to be able to investigate and prosecute fraudsters who steal taxpayer dollars that should be dedicated to providing critical health care services to Minnesota's most vulnerable people. Now, with a brief overview of who we are, our Medicaid Fraud Unit has existed for over 40 years. We are one of 53 in the country. Every state has one, as do DC, Puerto Rico, and the U.S. Virgin Islands. Each Medicaid fraud unit in the country is funded by a federal grant from the Department of Health and Human Services Office of Inspector General. That grant covers 75% of our funding. All costs, staff salaries, technology, rent, you name it, it's covered. But it comes with conditions on what we can and cannot do. It requires us to spend 100% of our time on specific activities defined by federal regulations. And what do we do the most? We investigate and prosecute Medicaid provider fraud, which we have original jurisdiction to do under state law. And we can investigate and prosecute certain crimes that come out of provider fraud. Most often, these are money laundering or other financial crimes. We can also do patient abuse and neglect crimes. That often means crimes against vulnerable adults or elderly residents in nursing homes, assisted living facilities, and other similar settings. We don't have original jurisdiction for that, but we can prosecute it upon referral from county attorneys, which in the last 4 months has included financial exploitation charges against an individual in Chippewa County and abuse and neglect charges against a corporate actor and 3 individuals operating an assisted living facility in Anoka County. Finally, we can assist federal law enforcement in their provider fraud investigations. This can include interviews, data analysis, assistance with executing search warrants, and other matters. Our investigators spent most of their time last spring, summer, and early fall on tasks like this when they worked with agents from the U.S. Department of Health and Human Services, Office of Inspector General, and the FBI performing data analysis and field work. With those federal requirements and funding come certain prohibitions too. We're the investigators and prosecutors, but we are not the administrators of the program. For example, federal regulations require us to be entirely separate from the agency that administers the Medicaid program, which in this state is the Department of Human Services. So we can prosecute it, but we cannot turn off payments on the front end or bar a certain provider from enrolling with Medicaid or continuing to receive payments. We cannot do compliance work like that. We also can't investigate or prosecute fraud in obtaining benefits, also known as welfare fraud under our statutes, or fraud in other public programs like child daycare. Now, this act covers both a budget and a policy request. Our budget is what I'll cover first, and as I mentioned, it's annually approved by the U.S. Department of Health and Human Services, which pays for 75% of our costs like it does for every Medicaid fraud unit. And each med fraud unit size is based on the size of the state Medicaid budget. So for example, California has a much bigger Medicaid budget than we do. California has hundreds of people in their med fraud unit. South Dakota has a much smaller budget than we do. They only have a handful. And our staff size is presently 32, which was set in 2019 when our state Medicaid budget was $13 billion and when we were getting about 150 referrals a year. Our state Medicaid budget is now well over $20 billion with many more enrolled providers than before. And in 2019, when we went up to 32 people, we had 144 unique referrals that year. We've been well over 200 referrals the past few years, which is an over 40% increase with no additional people to take on that work. And just to put a finer point on it, since October 1st of this year, we've already received over 300 separate referrals, which already exceeds what we've received every year in the past, and that's just through early April. We have another 6 months to go in our federal reporting period. Yeah, we still have only 32 people to investigate and prosecute, and that's not sustainable if we want state prosecutors to be able to hold fraudsters who defraud the state accountable. And just looking at us compared to other states, you'll see how much smaller they are than some with similar budgets. You have some of those numbers in your handout. You'll see that many of these states have smaller Medicaid budgets than us or similarly sized ones, yet much larger staff size. But that size hasn't stopped us from getting results. The investigators and prosecutors in the division have done great work. We regularly exceed other units with many more people in fraud convictions. We had the most from 2020 to 2022 during our audit period as compared to similarly sized states with staff between 22 and 38. And that's continued since then as the past few years we've outpaced others. Last year, we ranked 6th in investigations for Medicaid expenditure, 5th in fraud charges, and 8th in fraud convictions in the entire country. And we don't have a top 10 staff size. We're in the middle. And just to discuss the long term, we're on average 5th in fraud convictions in the entire country over the last 6 years. That's a long-running track record of success for our unit when compared to other states. So we're asking you to fund the 25% necessary for us to expand to 50 people, which will give us the resources we need to hold people accountable at the state level. You pay 25% and the federal government pays 75%. So out of 18 people, you're paying for about 4.5. That's a good deal for the state, and it's warranted not only based on the size of our Medicaid budget growth, but the dramatic increase in referrals. We're also asking for policy changes. That includes amending the medical assistance fraud statute to cover current gaps within it. The new statutes address issues our prosecutors face every day in district courts and help ensure that fraudsters can be prosecuted. Right now, our statutes just cover intentionally submitting false claims for reimbursement. Some judges read that language in the statute as covering a very narrow course of conduct when we all know fraud occurs in other manners too. This policy change addresses those gaps. That's done by, as you can see, covering a variety of different ways that fraudsters try to steal from the Medicaid program or escape culpability. Intentionally providing false information on enrollment documents to conceal the identities of people who aren't allowed to be providers. Intentionally falsifying medical assistance records. Intentionally destroying records in response to a lawful request. And while this covers different conduct, it still ensures provider rights are protected and we're not catching accidental mistakes. That's done by requiring that we as a state prove intent to defraud for these violations. Intent to defraud is a specific legal term. It covers the mens rea or mental state the state must prove that a defendant has when the crime is committed. It's the highest level of mental state that exists in criminal law. We've proven it to juries before, and we will continue to do so if you provide us with this amendment. The statute also equalizes penalties with other statutes and includes a new provision targeting the most egregious offenses over $1 million as a separate penalty provision. And this ensures that we have appropriate accountability for those who get obscenely rich stealing money that's supposed to go to the most vulnerable people in Minnesota. And the new provisions regarding restitution and continuing offenses help ensure the offenders are ordered to pay all of the money back. And the remaining provisions ensure that we still have original jurisdiction for these offenses and grant us the subpoena power. For the subpoena power, we're asking for similar subpoena power that county attorneys have when they conduct criminal investigations. This revision would allow us to subpoena financial records in provider fraud investigations conducted under 256B12. County attorneys already have this authority when they conduct welfare fraud investigations, also known as Medicaid recipient fraud, and state agencies like DHS have this authority when they conduct their investigations, and the federal government has this authority when it conducts investigations into healthcare fraud. So granting us this enhanced authority, which only applies to Medicaid fraud investigations and is limited based on the recent amendments, is consistent with the judgment that investigating authorities should all have equal power to subpoena financial records when they're investigating people for defrauding public programs. So that's our request, and we'd ask that you give us the funding for more people and the statutes that enhance the state's ability to investigate and prosecute so that we as a state can continue to hold fraudsters accountable. Thank you.
Thank you, Mr. Wonka. We do have a couple of amendments, but before we get to that, I just wanted to get one clarifying piece from you. When the intent to fraud conversation, in talking with General Ellison, I raised, thank you, this is what we've been waiting for, that's the fiscal note. The fiscal note's being passed out, folks. In talking with General Ellison, knowingly or there was a few things. And the first one is the issue, the standard of knows or has reason to know standard. Just stay with me. You got intent to fraud, right? There's a willingness, I mean, I don't want to get into those. But if your backstop on that is that it has to be a threshold of proof beyond a reasonable doubt is the word you use, correct?
Mm-hmm. Correct.
I'm not a lawyer. I played one time, I think. But my concern is this. The devolution of information down to the program staff level. You got lawyers in a room. God bless you, lawyers. But when somebody's applying the work, the process work, there's real no communication on that level unless you articulated and put in a system that helps people understand there's a difference between a simple clerical error or something that is done. Because the concern that I have is when you expand the investigatory reach and you lower an intent threshold, there's a systemic complexity that is now already in a really complex system. You're not addressing the complex system. That's not your job, right? But clause is this, devolution of information down to the people that are doing the day-to-day. There's still a gap there, and I'm not convinced that you've addressed that gap. And so how are you going to address that gap of the things I just threw out at you?
So I think provider education about these things, about everything in the law is an important piece. One thing that we as a Medicaid fraud unit do now is for newly enrolled providers, there's a steps for success training that they're required to attend. And we present at that training. We have a presentation that we have given for years that is based on what the law is now. That will need to be revised, certainly, if these statutes are amended, so that we are going into details about these different things are now within the criminal statutes. There are some pieces here, though, everything that we are adding is a specifically delineated crime is either already prohibited under federal law, right? So these aren't new things. And I understand the communication piece to people about, look, you can't do this, right? Like you can't let somebody who is an excluded provider run your agency without disclosing them. That may not be specifically delineated in a criminal statute right now at the state level, but there are federal laws covering that, and that is something that is in a provider agreement as well. And so our education piece for newly enrolled providers is going to be at Steps for Success, to be where we continue to present at that. For currently enrolled providers, that's a separate issue, right? But certainly, we have appeared at different conferences and things like that in the past, to talk about our work. We will need to do more outreach on that point, I think. We are always happy to do it with the Department of Human Services at anything that they're doing, because, as you noted, they do different work than we do. They have different administrative provisions, which, quite frankly, cover a lot of different things that we're not looking to criminalize, but that they do, that they still require. And so our appearance at that is going to be absolutely vital to making sure that everybody on the ground who is doing the day-to-day work knows what these law changes mean for them.
So provider, one thing, the agency is the other. When you look at administrative errors or misunderstandings that may be, permissive language, may be treated as criminal behavior, there's some concern there. And so I'm still not convinced that I would like to see devil in the detail, on the rollout of these new changes, right? Specifically to the agencies, because then you have lead agency involvement. You know what a lead agency is, right? It's the county. You have all these different layers. When I said a systemic complexity, it is very complex. And so I'm going to hold off on that and before some other questions. We have the A14 in front of folks. Mr. Raymond, could you please explain the A14, please?
Yes, Mr. Chair, members. The A14 amendment, this was at the request of nonpartisan staff in the Health and Human Services Committee. So my understanding is there's the fiscal note for which I believe was passed out, included a cost to the Department of Human Services related to increased documentation requests from the Attorney General, as well as additional participation in legal proceedings. There was that fiscal note was not available at the time this bill was heard in Health and Human Services, so we were asked to include the appropriation that provides an appropriation in the exact amount of the fiscal note.
Thank you. Members, I guess the question, is this cost item coming out of our human services bucket, Mr. Raymond?
Mr. Chair, no.
Thank you. Senator Gruenhagen, question to the amendment.
Yeah, so what is the 85,000 being used for?
Mr. Raymond?
Mr. Chair, Senator Gruenhagen, so this is for the DHS included in their fiscal note that there would be an additional cost related to additional documentation requests from the Attorney General, as well as additional legal proceedings. So it would be, it results in about 2 FTEs, and there's a 29% state share. So this cost to the state would be the 29% of those 2 FTEs.
At the department. Senator Abler.
Well, thanks. And so this probably comes out of the other committee's money, but it comes out of the big bucket. And so maybe I can just ask a question on all the money. This requires a general fund appropriation for real to make this happen. There's going to be a big budget bill leaving, which is like a big hot air balloon, it seems to me, with more than $1 billion in spending. But for this to actually come true, we actually, and that's going to go over and probably go into some kind of a bug zapper. But for this to actually occur, at the end, the leaders have to agree to spend $1 million or so on this, which I think is actually a good idea. So I just wanted to mention that.
No, I just said thank you for that. We raised the issue. So any other questions on the A14? I saw Senator Makewaite. No. All those in favor of the A14 say aye. Aye. Opposed, same sign. Thank you. Members, now we go to the A13. Senator Rasmussen.
Thank you, Mr. Chair.
And the pages will be passing out the A13. So Senator Rasmussen, talk about your A13.
Thank you, Mr. Chair. I'll move the A13 amendment. And this is a simple amendment on a complex topic. It just adds 2 words clarifying that data on individuals held by the Attorney General's office is classified as private data on individuals. And Mr. Chair and members, the intent of this amendment is to bring more transparency to the Office of Attorney General, and especially when it comes to fraud, making sure that the public has the access to data that they have had access to for decades. The reason that this policy language is needed stems from a 2022 Minnesota Supreme Court case decision, Energy Policy Advocates versus Ellison, where the case was decided on a 4-3 split. And basically the court determined in that case that, and I know this sounds odd, so you'll have to hang with me here, they said that data not on individuals maintained by the Office of the Attorney General is private data on individuals. And if that sounds odd, Justice Paul Thiessen agreed, and he led the dissent in this case. And I'll just read a couple quotes from his dissent because I think it's very telling. He said, "This reading of the act, that there is a special, somewhat Orwellian Attorney General definition of private data on individuals that is not limited to data on individuals, is not a reasonable textual interpretation of the act." And then secondly, he said, "Certainly the legislature nowhere explicitly stated that it was creating a second alternative definition of private data on individuals that applies only to the Attorney General." And so I want to be clear that if this amendment is adopted, this goes into law, data on private individuals will still be protected. That was the intent of this law in the first place, and we're just clarifying that the protection on private data on individuals is only for data on individuals, and it isn't a blanket prohibition from being able to have access under Minnesota data practices. Right now, all other state agencies are subject to Minnesota data practices requests except the Attorney General's office. This amendment would restore parity across state agencies, and it would revert back to what Attorney Generals have been providing access on for decades. And especially as we're dealing with this fraud crisis here in Minnesota, I think transparency is an important step to rebuild Minnesotans' confidence in our ability to protect taxpayer money and ensure that those dollars go where they're supposed to go.
Senator Eric, I was going to say data, we're talking data privacy here.
No, we weren't. But yes, I would love to talk data privacy. Senator Seeberger, I know you're the only person in this room who's on the Judiciary Committee. I know this is a bill, Senator Kroon's, and I don't know if this isn't the right committee, I think, to have the conversation, so I'm just wondering, has this come before Judiciary, or do you have any thoughts on this amendment, since we are amending Chapter 13 here?
Senator Seeberger.
Thank you, Mr. Chair. Thank you, Senator McQuaid. While this bill was heard in the Judiciary Committee and Senator Kroon is on the Judiciary Committee, I can tell you I have no memory of whether this was part of our discussion. The bill was amended in Judiciary for different provisions were amended, but you are correct that this is something that is in the purview of the Judiciary Committee and certainly would be more properly heard there.
So can I just ask a clarifying, Senator McQuaid, and then we go to, but if we're talking about PIN here, we're talking about individuals, I see this broad scope of this. All of a sudden we have this inquiry going on. So I have an individual that was receiving services, an individual, so individuals, right? These are people that are entrusted to this committee. And I like this because it assures some protections, if I'm reading that correctly. So I don't know. I think there's a joint piece here. I think it stays within our purview here. So that's just my piece on that. So Senator Mayquade.
Thank you, Mr. Chair. I think, I'm sure at some point it involves us, but this is very, very clearly just in the Judiciary Committee because it's just amending Chapter 13. And so it's, I mean, it ostensibly could go to every committee, right? Because it could be education data, it could be, deed data. And so I think my question is then if we amend this on, will Senator Latz bring this bill back to Judiciary to give it a different hearing because this wasn't part of that committee stop?
That's a great question. Does that need to go to Judiciary if it's put on this bill in the amended form here? Do you know the answer to that, Mr. Monahan?
Mr. Chair, members, a committee chair can always request a re-referral on the floor.
Thank you. So that answers that question. Senator Abler to Senator Mayquade's point.
She can,
Or she can go ahead, Senator.
Thank you, Mr. Chair. And Senator Seeberger, did you say that this bill that Senator Kroon brought, it was amended in Judiciary Committee?
Senator Seaver.
Thank you, Mr. Chair. Senator Mayquade, I don't recall hearing this in Judiciary when we heard the bill. I recall hearing other amendments. I don't recall hearing this. Doesn't mean we didn't hear it and rejected it there. It just means I don't have a memory of that. Maybe, Mr. Wonka, do you remember whether this was presented? I don't think it was, to be honest with you.
It was,
Mr. Wonka.
it was not offered as an amendment in Judiciary. I think the topic came up, but there was a remark saying that we're not going to offer it as an amendment today in Judiciary.
Senator Mayquade.
I'm just having flashbacks to the floor when Senator Latz was putting people on notice that if we were going to be amending things about contracts in Chapter 13, that he wanted to see it, and that was just, what day is today? Wednesday, so Monday. So this isn't the merits of the amendment. I just am trying to be, it sounds like this is a conversation that involves the Supreme Court and data practices and the Attorney General. Like, this is just not the venue to have that debate and that conversation. And so
Thank you for that. Senator Fatah.
Thank you, Mr. Chair, and I agree with Senator Mayquade. I just looked online, and I don't think it was established as an amendment, but it also was referred to the Judiciary Committee as a bill itself by another senator, and it hasn't gone to hearing either.
Senator Rasmussen.
Mr. Chair, the language in this amendment is from Senate File 730. It was given a hearing last year in the Judiciary Committee and laid over.
Thank you. That answers Senator Fatah's point. I'm concerned that the issue of people in our purview in the human services world need to be protected, because the concern from the very beginning, the risk is that you have when you don't have clear, concise directives on how this is going to roll out in the programs, right? And we're talking about 65 and older are now 1.3 million people. 20% of the population have somebody with a disability. 25% you have a chronic. This is not just a small amount of people. There are some privacy concerns. There is also some fear and confusion among families about the rollout. And this is when I met with you, that's all I kept talking about, devolution of information. How is it done? And then the other thing is there's a potential for targeting innocent, because the end game is we had people die because decisions were made without our input. Now I'm going to start to ramp up, because at the end of the day, Mr. Wonka, I only care about the people that are receiving the services and the people that are paying for those services, right? The agencies, absolutely. The bureaucracy, just like all of us here, we're, there's one election away from not being here. So, but if we don't do our job to set up a system that is fully intact and people understand how they do it, it's been age-old conversation Senator Abler had when he was in the House. Senator Abler.
well, I think it's important. I think this is solid. I think it's our purview to decide we want to do this. I think we should just take the vote and see where they are.
All right. Any other comments? To the 8th, Senator May Quaid, or do you want me to go to Senator Seeberger?
Oh, yeah, Mr. Chair, I was just saying, do you want to go to Senator Seeberger and ask her?
Senator Seeberger, yeah, I should ask. Welcome to the Human Services. Senator Seeberger, your opinion, please.
Thank you, Mr. Chair. As to the merits of this, I don't personally have an opinion. I do know there's someone here from the AG's office who could possibly speak to it and let you know their thoughts on it. I have had a conversation with Senator Rasmussen on this, and I've discussed it with some other folks in the Senate, and I've heard different opinions on whether it's appropriate or not. My preference would simply be to put it to a vote to the committee.
Thank you. I'm hearing people on the committee say we want to hear from the AG's office. Did you have somebody that's in-house that you want to bring up, Mr. Wonka?
Yes, Oliver Larson from the Attorney General's office is here, and he can speak to the data practices piece.
Thank you. For the record, please state your name.
My name is Oliver Larson. I manage the Environmental and Natural Resources Division at the Attorney General's office. I'm also the attorney who handled the EPA versus Ellison matter.
So can you go back and explain, you're the lawyer for what, Environmental and Natural Resources?
Yeah, I'm the attorney. I manage our Environmental and Natural Resources Division at the office.
Okay. Senator May Quaid.
Thank you, Mr. Chair. And I think that even having an attorney in the Environmental and Natural Resources is showing that this amendment isn't about individuals who receive Medicaid. This amendment is about all the data that the Attorney General's office collects. And
Okay.
and it's about a case that deals with energy and environment. And so it's much more enterprise-wide impactful than just like Medicaid. And that's why I think judiciary is a better venue for this.
Thank you for clarifying that. I appreciate that. So, Mr. Larson.
Yeah, let me start with this. There may be some data around the periphery, but all of the data that would be housed within the Medicaid fraud section of our office would not be classified under 13.65. That data would be classified under 13.82, which is the provision of the Data Practices Act that deals with comprehensive law enforcement data. And because they're generally in the business of doing criminal prosecutions, their data is classified under that statute, not under 13.65. And so even if this amendment was passed, like I said, it's not data that is related to Medicare fraud. That's not what's going to be covered by this amendment. What is going to be covered essentially is other data in other places in the office.
Mr. Larson, could you explain that to me in human services terms? There's and what I'm getting this theme. There's some, and I've raised this to General Ellison, is that there's a lot of ambiguity in this language that I'm reading, and that your response was very ambiguous. So if you could, for me, I need to understand the contextual argument that you're doing there. So if you could explain that to me.
So the provisions of the Data Practices Act that are most commonly applied to our office would be Section 13.39. That's a section that covers civil investigative data. There's another section, 13.393, that covers attorney data. There's the 13.65. That's the provision that's specific to our office. And then there's 13.82, which deals with law enforcement data. And depending on where you are in our office and what kind of data you're dealing with, one of those four provisions of the Data Practices Act is where the data will be classified. And now there will be some data in our office that may be classified under more than one section of the DPA simultaneously. For example, something can be both attorney data and civil investigative data. The data that's classified under 13.65, it's a little bit of a hodgepodge if you take a look at it. The EPA versus Ellison case was mostly about the provision that would be subdivision 1, it would be B, which is communications and non-investigative files relating to administrative or policy matters which do not evidence final public actions. That was the primary provision that was at issue in the EPA versus Ellison case. I'm not aware that there would be any data inside of our Medicaid fraud unit that would be classified under that section of the DPA.
Senator Rasmussen.
Thank you, Mr. Chair. I would just say that general policies around what the office is working on and how they are approaching overall Medicaid fraud would be covered by this, and that's why I think it's important to have this transparency so we understand what the office is working on and what they're not working on.
So I wonder why didn't judiciary, I mean, this is serious stuff, Senator Mayquid. Why didn't judiciary, I mean, all of a sudden, I'm glad he brought this up to us because now I have concerns about this bill going forward and in the internals of this bill, right? And this is one of those points. Go ahead, Senator.
Thank you, Mr. Chair. I mean, I think, so it sounds like this was given a hearing last year by Senator Latz and the Judiciary Committee. Senator Rasmussen told me that. And so I think the fact that we've had 2025 and 2026, right, because we've had Senator Latz's omnibus bill this week, yesterday, it tells me that there's something that hasn't been fixed. And I believe the directive that was given by Senator Latz to Senator Kroon was to work with the Attorney General's office to find language that that gets people to where they're like, this is good and we're doing what we wanted to do. I don't know if they're there yet, and I think that's why we're seeing it in this committee and not on an omnibus bill related to Chapter 13, so a judiciary omnibus, or in the Judiciary Committee. And so that's why I don't disagree with the point that Senator Rasmussen is making. This is just the wrong committee to be making it in and the wrong bill to be attaching it to. And so that's where I'm at.
No,
Mr. Chair.
I appreciate your insight on that. Senator Abler.
I think this is the right committee, and I think we need to protect all of our individuals that are in our purview. We've got 150,000 or something, and how many providers and all that. And if it doesn't happen here, Mr. Chair, it's not going to happen.
Thank you.
Yeah, if we don't do it here, it's not going to happen.
Yeah, and that's,
and so if you want to press the issue, then stick it on the bill. Vote how you vote. But I'm going to vote yes, because I would like this to be there. There's Paul Thiessen, Justice Thiessen is brilliant. And I think the Supreme Court got it wrong. And I think we can correct that wrongness and protect the people. And the statement from this committee would be like, let's protect them. And then this bill is going to go forward. And very frankly, the more we include more bipartisan ideas in this bill, there's a better chance the whole thing's going to become law. This bill has to get across the street, and it has to get people in both caucuses over there to agree to give Keith Ellison some money. And I wish that it was just an anonymous AG. I'm giving the anonymous AG money to continue the work. Unfortunately, there's a personality there which is relatively large. But even so, I'm going to urge my colleagues to support this, because we have to deal with these issues, and they need more staff and all that. So that's I think we should put it on today, Mr. Chair.
I'm going to get clarification from council and then let Senator Seeberger. Senator Mayquid, you want to get one more word, and then you can talk. I'm going to talk to council and then Senator Seeberger.
The only thing I would add, Mr. Chair, is that the goal of this amendment is to make less data private, which again, I don't disagree with, but that's the intent of the amendment. And so for those concerned about data privacy, this makes less data private, not more.
Senator Seeberger.
Thank you, Mr. Chair. A couple of things. Yes, Senator Mayquid is correct that my understanding is Senator Kroon was invited to work with the author of the bill in the AG's office to come up with language that would satisfy all parties. And my understanding is they're not there yet. As to Senator Abler's point, you are correct. This bill will deal with any AG, not just this AG. And that has been some of the concerns underlying many of the conversations around this bill as it has progressed through committee this session. As to the amendment itself, reaching beyond only Medicaid-related investigations, that was a topic of discussion in judiciary with regard to subpoena power. And the subpoena power in judiciary was limited to cases involving only Medicaid fraud when it came to employment records and insurance records. So that discussion was had, and I think it's a good discussion, because with this bill, do we want to limit it in scope to Medicaid fraud, or do we want to include other areas that perhaps need to be addressed? Once the subpoena power was limited in judiciary, Senator Latz disagreed with that and directed staff to draft a bill to allow subpoena power consistent with county attorneys. So we're seeing the tension. Do we address it in this bill? Do we address it somewhere else? Do we have a separate bill? What does the legislature want to do with this? And I think those are all fair questions and subject to discussion. I will note, if this amendment goes on, I'm pretty sure Senator Latz will want to hear it. And I've devoted most of my Fridays this session, Mr. Chair, to hearing bills coming through judiciary, and I would expect that I would do it again.
Senator Fata.
Yeah, thank you, Mr. Chair. And I just want to highlight and emphasize what Senator McQuaid said. So to be clear, this does not protect more data. Is that correct? Senator Seaborger?
Senator Rasmussen.
Thank you, Mr. Chair. Yes, to clarify, this would protect data on private individuals and keep that protection. However, if you have data that's not on individuals, then the same standards that apply to every other state agency would apply to the Office of Attorney General, which applied for decades before this court decision in 2022. We are doing what Justice Thiessen argued for in his dissent. We're doing what decades of attorney generals had to live under, and so we'll just be improving transparency into the Office of Attorney General, and that's why I'm supporting the amendment.
I'm enjoying this conversation because it's getting to the essence of why we do what we do. The question we asked 3 years ago, right? Senator Fata and then Senator McQuaid.
Yeah, thank you, Senator Hoffman. I would just like to hear from Mr. Larson on clarification or if there is agreement on that.
So let me say a couple of issues.
Excuse me, Mr. Larson.
I'm sorry.
Chair.
Oh, I'm sorry.
I'm just
trouble
not,
with my eyes, so Chair
well, there's a process. Since you guys are lawyers, you like processes, and we have a process here, so, that is funny. I like doing that. So, Mr. Larson.
Chair Hoffman, Senator Fata. So let me say a couple of things about this. This bill has implications that will not be obvious from the presentation that has been made to you today. So, for example, one of the issues that we have in our office is we're looking at, the agricultural industry, and there's been a lot of consolidation. There's a lot of work going on there on antitrust work. Now, here's the thing. If you are a small farmer in Minnesota, you're probably organized as an LLC. So if you are a small dairy farmer who's got 50 head of cattle and you want to make a complaint to our office about the fact you're not being treated fairly by the company that's purchasing your milk, and you're organized as an LLC, if you make that complaint to our office under this bill, that data will no longer be classified as private data, meaning that when you make a complaint to our office, it's now public data at some point. That has very serious implications for our ability to conduct antitrust investigations if we cannot assure small farmers who are reliant on their ability to sell their products, whether it's chicken or milk or a product like that, to a consolidated purchaser of these products. If we can't assure them that their complaint is going to be confidential, our ability to do that work is impacted. And I don't think that should turn on the question of whether that small farmer is organized as just an individual person or organized as an LLC. And that's one of the issues that we identified when this bill came up in the past, is that when you say the distinctions between LLCs and individuals are not as clear as you think they are. So that would be an example where there's going to be serious impacts outside of what's in front of this committee right now. The other thing I will say is that the interpretation that the office currently has on these issues that was vindicated in the Supreme Court is longstanding. And in fact, the decisions that were made on the data that was litigated in the EPA versus Ellison case, those decisions were not made by AG Ellison. They were made by the prior AG, AG Swanson. So the data request that came in that led to that lawsuit came in 2018 and in the first month of 2019. And so it was AG Swanson who made the determination to classify the data that then led to the lawsuit that ultimately led to the Supreme Court affirming the office's interpretation of this statute. So the idea that the office has adopted some new interpretation of 1365 or there's something specific to AG Ellison is not accurate. These are longstanding interpretations.
So I'm almost convinced Senator Latz needs to have this debate, because there's something that just hit me when you were talking, in the side conversations. This is great. This committee likes to have these conversations. A 911 call was released to the public, and my address was popped on the TV screen. Y'all did nothing to protect my privacy, right? No, don't mean y'all. I mean y'all. The system did nothing. There was no assurance of privacy. Matter of fact, there was a debate between some individuals in Hennepin County that got into a match. One didn't know the other one was doing what they did. And lawyers in your division were saying, oh no, this is how we do it. I'm not buying that. And Senator Rasmussen, I'm almost convinced Senator Latz and those lawyers need to geek this out. I mean, I'm not a lawyer. We're all, well, you might be. Are you? No, you it's so, do you hear me? I think it's well worth the stop, Senator Seeberger, because you're raising, not only raised my temperature a little bit, but you're raising some serious concerns about is this or is this not. I'm glad Senator Rasmussen brought this point up. So contextually, I think this needs to be argued amongst you people that have a JD certificate after your name. That's my opinion. So I'm going to support this amendment, right? I'm convinced by that. And just in our discussion, I think Senator Latz needs to have this in front of him, this specifically. That's just how I'm doing it. So Senator Mayquid.
Thank you, Mr. Chair, and I'll just say two things. The one, the thing that I want to be really clear about how this came to us is because the fossil fuel industry was trying to investigate their way out of a lawsuit for contributing to climate change. And so when big companies come into the state, and we have a different bill because Meta did the same thing when 46 attorneys general sued Meta, they were like, okay, give me all the data from your entire state. And so what's happening now is we have these ultra mega corporations that when they get sued for harming people, they find every single way possible to make it painful for states to stand up for regular people. And so I'm thinking about my modification bill that I hope we're going to pass. I have a feeling that the mega tech companies that, will not want to be sued are going to come after the parent groups that have formed because their kids died by suicide from being sextorted, like we heard Senator Lang talk about yesterday. And so the fact that the decision in this case that the Supreme Court made, which was in the affirmative that the Attorney General's office did the right thing, is coming to us from the actions of the fossil fuel companies, doesn't bode well for my inclination. Fossil fuel companies or tech companies, these are the people that are coming after our state for this data. It's not like, regular citizens. And so do I want a health insurance company to be able to sue the state of Minnesota and get a bunch of stuff on conversations that they've had about us going after the health insurance company for, screwing people over? Not really. Because that's who is coming after the Attorney General here, and that's how it originated. So that's why I don't want it to go on here, and I want it to be decided in judiciary. If the bill is good enough, they can have that debate. It's already in judiciary. They can bring it up, they can talk about it, and we could amend it on the floor. But if we add another committee stop, we have 3 weeks left. And I don't know if this bill, which is very important, has time to travel to rules, then judiciary, then rules, then wherever it needs to go next.
I think to that point, thank you. I think to that point, we could just do we could re-refer it to judiciary from here and just have Senator Seeberger get in front of Ron. Does it have to go to rules first, Mr. Monahan? It's a late bill, so it would have to go to rules. All right. So rules would have to intercede between. Well, then they got work to do. Because I'm hearing our argument, and I really wanted to get to some contextual stuff. I've used that word 3 times now today, so you guys are gonna count on that. But it'll pass. I like what Keith Ellison is doing here. I don't like some of the gaps, and I've talked to him about those. I'm still going to raise those because here's my point, folks. People with disabilities should never become collateral consequences of fraud enforcement policy, right? Should never. Fraud enforcement policy, but it should not be. And we've seen people with disabilities, and then you could just watch AJ Legault on Care 11, right? Those are real people. Those are real travesties. The system did not. We need to strengthen the program integrity without compromising care. There's a continuity of service piece that I am stuck on, and I will be stuck on. It's in the rules of CMS. States must assure. It's not permissive language. It's must assure continuity of care. So let's get it right. Let's protect the system. Let's protect the taxpayer and protect the people who rely on it every single day. I think we can do that. This is what this conversation is. So no more debate on the A13. All those in favor say aye. Aye. Opposed, same sign. The A13 is passed.
Mr. Chair.
Senator Abler.
To the bill, and I think we're on a good track here, and it'll be discussed, this topic. This is not my main topic with the bill. I'm glad it's there, and we had that chat. But to the bill, the way it stands, the concerns you raised, I'm glad it's a reasonable doubt standard, which is really high, for people that didn't even know what their company was doing. But I'm still concerned, and maybe if it goes back up there, they can make sure, Senator Hoffman, that no innocent person is snagged. They had intent or had reason to know. Is that still in the bill, the reason to know part?
Yeah.
And so I'm just concerned, you get
knowing.
Nobody wants fraud. But this has to be fixed, I think, just along the way to make sure that no dolphins get caught in the tuna net. And Mr. Chair, today they are. And especially given that once you get snagged by an indicia of suspicion, which is like, we think there's something there, and they get sent over across the street, which is why we need more workers there. It's 1 to 2 years to get adjudicated. Sounds like if you're lucky. And in the meantime, your business is gone. You didn't do anything wrong, but you had reason to know, or an indicia. I'm concerned about that low bar, and so I don't know how to fix it. And I know I'll be reassured by the people at the table, no, this is not what we intend. I understand that's not what you intend, but later you put it in words, and then you get the Thiessens of the world, the Supreme Court, or whoever fighting about, well, that's what the words say. So I just want to make sure, Senator Seeberger as well, that you're a highly responsible, respected author. You're a good choice for this bill, but that remains my only concern, at least my biggest single one that I still have. So I just don't want to snag. You're a 5% owner in this thing, and you thought it'd be fun to have a share of some one of these companies. And so, maybe you're a private equity guy, and perhaps, and you decide you're going to help this company get a foothold, and you're actually a legitimate, nice one who's there for all the right reasons. Of course, you have no idea about the day-to-day operations of anything, and then they could be snagged as well. And I don't think we want that. Or if it's just some grandma who helps chip in some of her savings to help her granddaughter get in business, now she's going to have to go to some hearing about something. So I think I'm just tracking with you and just reiterating, but I like the bill. It needs to pass. I don't know how anything passes these days going across the street in a world where they can sometimes not even approve their minutes. But I, for one, am going to be encouraging people to support this effort today. Thank you.
So before I go to Senator Utke, can I just add to, is that okay? Senator Abler, there's that focus on enforcement, but there's no parallel. I'm not hearing a parallel system reform. And then we'll go Utke, then to Senator Gruenhagen, and then Rasmussen. But it's like you're raising some good points. Here's something I just found out. Rules has waived this bill needing to go to them. So we're just go to judiciary and then to the floor or to finance. So I think we're okay. This is good. I'm going to watch that debate. Senator Utke.
Thank you, Mr. Chair. And just one word of caution, as we always say, all good things that go to judiciary go there to die. So we got to make sure about sending it to judiciary if you want this bill. But anyhow, but this one's going to sail right on through. Okay, gotcha. My first question is for Senator Seeberger, being she's blessed with the job of bringing this in front of us here today. The topic we're talking about, fraud, is #1 issue across Minnesota. And the AG's office is currently the main investigator and prosecutor of fraud for MA, et cetera. This is, of course, addressing it a little bit further and in detail. But do you personally believe the AG's office is currently doing a good job working with and prosecuting fraud?
Look at this. I love that. Senator Seeberger, it's the personal opinion of a lawyer. See how the lawyer, I love it. I'm kidding.
Mr. Chair, Senator Utke, first I need to correct your statement. Judiciary is where hope goes to die, not the bills.
We're good. Oh, God.
Secondly, Senator Utke, I'm disturbed by the pattern of fraud that has occurred in the state of Minnesota. I'm encouraged by the prosecution that has taken place lately, but I will note that very little was done when the Republicans controlled the Senate to address fraud that was happening at the time. So I'm not encouraged by past actions by your party to hold anybody accountable. I'm grateful that folks now are being held accountable.
Senator Utke.
Thank you, Mr. Chair, and thank you for that. I truly believe, and again, this is my opinion, that the only reason why there's something going on currently is because the feds came in a year or so ago, which I don't care how we're getting it done, at least moving prosecutions forward concerning fraud are extremely important to everyone here in Minnesota. Now I'm going to switch over to the AG's office a little bit more. Last week, I believe it was when you were in front of HHS, I'd asked the question, and I'm just going to ask it a little differently this time, and that referred to the number of people that you currently have in the total office and the amount that are focused on the current medical assistance fraud. And I'd asked, why aren't we shifting some people? And I understand the fact that they'd have to be permanent hires. They'd have to be there. But why can't we do that? Why aren't we doing that? Moving a section of staff over to be permanently in this division. The people of Minnesota, this is their #1 issue is fraud. That's all we hear everywhere we go. And I see what I consider some real failures coming out of the AG's office, and not blaming you guys. When we point fingers, it always goes to the one in charge, so it comes from leadership. But the fact is, the office is prosecuting a whole lot of things that we would all say are useless. We're wasting time on, we're going after entities that we should not have any involvement in. When drilling back to, we've known about fraud since back in the early teens. Then we came up into the late teens. Fraud was jumping all over the place, coming from CCAP and other places. So we've all known about these issues, but the prosecution never took place. That's where I see the failure, and I again go back to, why didn't we just move people? And I understand you can't go over and say, you guys go over here and work this week, and you come back here next week. It's got to be a permanent move because of the federal dollars that are involved. But I do think that's a failure of the office. You know, I fully understand the request. However we get the job done to snuff out fraud, we need to do it. But I think we've dropped the ball. We can pick that ball up and play ball now, and let's move forward and get the job done. So thank you, Mr. Chair.
Points. That was good, Senator Utke. So we're going to go to Senator Gruenhagen.
Oh, thank you, Mr. Chair. Yeah, my question is for Mr. Oliver. I don't have your last name.
Larson.
Oh, Larson.
Yes.
Oh, no, it's the other attorney, actually. I'm sorry, you got it mixed up.
That would be Nick Wonka.
Nick Wonka, okay. Yeah, just on your testimony, it sounded like the AG does not have the ability, if you suspect rampant fraud in a particular provider, if I heard you right, correct me if I'm wrong, that you cannot pause payments to that provider until you get additional information, or is that true or not?
Mr. Wonka.
Chair Hoffman, Senator Gruenhagen, we in the Medicaid fraud unit have no ability to suspend payments to a provider at any point in time. The program is administered by the Department of Human Services. They suspend providers. We do investigations into potential crimes, but our ability to administer the program is zero.
Senator Gruenhagen.
Oh, thank you. Thanks for that response. Mr. Chair, another question. Okay,
Senator.
so Department of Human Services, do you coordinate with them if you're, if you think a provider has a lot of rampant fraud? Do you let the DHS know that this particular provider is under strong suspicion so that they can at least consider pausing payments if the evidence warrants?
Mr. Wonka.
Chair Hoffman, Senator Gruenhagen. So most of our referrals come to us from the Department of Human Services or from managed care organizations who would then also send it to the Department of Human Services at the same time. So they are typically already aware of our investigations when they're occurring. With that being said, we provide the Department of Human Services with a list of our open investigations on a quarterly basis. When we execute a search warrant, which would contain a finding of probable cause by a judge at a particular healthcare agency, we send that to the Department of Human Services. It is ultimately up to them whether they decide to suspend payments based on what we're doing. However, that is how we notify them of what our investigative activities are taking place outside of, what they may already know, given that they would have referred a case to us.
Senator Gruenhagen, follow up.
Yeah, thank you, Mr. Chair. Yeah, thanks for that response. See, one of the concerns I have is one of the reasons that we had a pause on federal matching funds is because payments continued to go out to these fraudulent organizations, and they weren't being stopped. Then you add to that in DHS, whistleblowers who brought this to the attention of the commissioner and others, they were being threatened and persecuted for that, to be silenced. And we've got that on testimony both at the Fraud Committee over in the House and also on published news reports. So it really concerns me that we have a Department of Human Services which has shown little ability to pause payments to fraudulent areas. And the result is it's endangering federal matching funds, billions of dollars of it, which then in turn relates to hurting the people that we don't want to hurt. Like Senator Aylmer said, the dolphins get caught up in the tuna net. So I don't know how to address that, but obviously it's in the purview of this committee, and I don't know if, Mr. Chair.
Senator, yeah.
I don't know how to address that because I sure don't want federal funds being paused, if at all possible, once session's over, okay?
Yeah.
Then people are going to get hurt again.
One of the things we've done in this committee is our work in the integrity side of it. That's as we're debating which path that goes, make sure, and I think everybody on this committee has gotten their stuff into that big bucket. Sorry, Christie, I said bucket. The big bucket of information that we need to have to assure that. And one thing Senator Gruenhagen's always brought up was that $500 million they're hanging that carrot over it. I think we have to assure that stuff gives the department the ability to do their job to assure that the bad providers are taken care of and sent up, right? And I think Senator Mayquade might have some addition to that, Senator Gruenhagen.
Okay. Oh, she's got additions. Oh, okay.
Yeah,
Thank
Senator
you. Thank you,
Mayquade.
Mr. Chair.
And then who?
And Senator Gruenhagen, I think it's very clear that the reason that we are being treated this way by the federal government is a retribution campaign. Actually, it's not clear. It's been said by the president. It's for retribution and revenge. But my question for the Attorney General's office, so the states with actual, the largest Medicaid fraud, Texas, Arkansas is the largest per capita, Florida, I think there was like a $15 billion Medicaid scam in Texas last year under President Trump's, during his administration. Did they have payment withholds from the federal government instituted for the state of Texas?
That's a great question. So, do you know the answer to that, Mr. Wonka?
Chair Hoffman, Senator Makeway, I am not aware of the large-scale payment withholds to all services like occurred here in Minnesota. For those specific providers at issue who were later charged, that may have been in place. Again, I don't have actual knowledge of that, but I did not see, from my reading of media sources, did not see a large-scale payment withhold to all Medicaid programs in the state of Texas, in the state of Arkansas, or in the state of Florida last year.
There was that $1.6 billion in Medicaid fraud for a private hospital in Florida. Yeah, I don't know. That's a great question. Maybe the department can give us that answer. So, and then when you're finished, I need to go back to Glenn, because that was a follow-up to where Glenn was started, so.
Well, that's fine, Mr. Chair. I think it's instructive for us to understand the disproportionate retribution, like stated retribution by Trump to the state of Minnesota. It's not a proportionate response to what we're doing here in Minnesota and with program integrity. It is revenge, it's retribution. And we know that because we have states that have like astronomical Medicaid fraud, right? Like we're not even in the top 10 or 15 in the country, not even close. But the states that are experiencing it, the red states, nothing's happening to them. In fact, some of them got pardoned, the fraudsters, by Trump. And so I want us to be really clear as we talk about this, that the people who are taking fraud seriously and instituting program integrity, like Senator Seeberger said, like we've seen it run rampant under a Republican-controlled Senate. We've seen it run rampant under a Republican Congress and at White House, and trying to do something about it and then, yelling about the inaction that Republicans took is frustrating. And I'm glad that Senator Seeberger is able to be here today to do this bill, because this is the kind of work we should be doing. But let's be really clear about how we ended up having Medicaid funds being withheld from the state of Minnesota. It was not because of anything in the state. It was because of retribution.
Yeah, and it's interesting you bring that up, and then we'll get to Senator Gruenhagen. That when you look at Minnesota, it's only at 2%. Fraud is fraud is fraud, right? This committee is the first to tell you, I don't care how it looks, smells, fraud is fraud is fraud. We need to do everything we're doing on it. And I think to Senator Gruenhagen's point, are we given enough tools to the department to be able to do their job? Glenn, to your points.
Oh, thank you. Yeah, I would just, without getting into the weeds, I would just say I strongly and respectfully disagree with Senator Makeway's comments. And Minnesota was exposed by Attorney Thompson to his approximation was at least $9 billion of fraud. So we can agree to disagree on that.
Okay.
Anyway.
So we'll agree to disagree on that.
Last comment.
Let's keep it focused on our committee, Glenn, or otherwise I'm going to ask you if you put green beans in your hot dish. Rasmussen after Abel.
There's a lot of members that don't trust the AG, and I guess I asked Attorney Oliver to respond to this, to prosecute fraud when Keith Ellison has accepted donations from some of the people currently being convicted of fraud under federal prosecutions. So how do we know this money is actually going to be used? Really, it's a two-part question. The other allegation that's out there is that the AG has not had any convictions in regards to Medicaid fraud. And you seem to give testimony to differ on that slightly. But if you can respond to the fact that we have the AG on tape implicating comments to people who are convicted of fraud in regardless to prosecution. If you would like to respond to that, Mr. Oliver.
Senator Gruenhagen, I'm going to move on. I appreciate you deeply, and I'm just going to, that's a campaign thing. I don't want us to get muddied. We can have our disagreements in here, but if you're okay with that, that to me has got nothing to do with this bill.
Well, I would like the AG to respond, but you're the chair, so you make the determination.
Oh, did you just hear that?
You know how respectful I am of you.
I know you are. That's what I like about you. Mr. Wonka, you don't have to answer that question because it has got nothing to do with this Amendment 813 or the Senate file that's in front of us. But so I'm going to leave it at that. We're going to go to, thank you, Glenn. I appreciate that. Senator Fata.
Thank you, Mr. Chair. And I just want to clarify a couple of things from Senator Gruenhagen, that the AG's office has their own process, and then DHS has their own process as well. From the investigative side to the DHS payment withholds,
Yep.
that the AG's office has nothing to do with.
And then Glenn
So-
asked, how are they communicating, Senator Fata? Do you know, so you got the two different systems, so,
Correct. And so there's some parts that I do agree with Senator Gruenhagen, but there's some parts I want to clarify also.
Okay.
For example, we know that this entire time that DHS did have the opportunity or the powers to withhold payments. They started doing it last fall. I think hundreds of providers got their payments withheld without any interaction with Mufuku, because I think there's like a 24-hour rule or something like that around that. That never happened. But payments were still withheld.
for those of us that don't do acronyms well anymore.
Medicaid fraud control. I apologize.
Mufuku. Did you ever hear that? Mufuku, you guys? Lately, I've been hearing. Okay. I love how you say that, by the way. I was going to say haram when you said that, man. I'm sorry, I didn't mean to interrupt you. But no, your 2 points to what Glenn had raised issue, and you said, okay, these are two different systems, so
Exactly.
keep going.
Yeah, no, absolutely. And so that demonstrates that those are separate. And so we also know that the AG's office, despite their limited budget and limited resources that they talked about, are still ranked nationally around charging investigations and fraud convictions. And so I just wanted to make that very clear, that just the processes are very separate.
No,
Mr.
gotcha.
Chair.
Yeah, to his
Yeah, I
point.
would just point out that Senator Fata at least agrees with part of what I said.
Senator Abler, no, Rasmussen and then Abler, I'm sorry. I messed up.
Thank you, Mr. Chair. A question for the Attorney General's office. Why isn't the Attorney General here today?
I think he's gone. I think he's he was testifying or doing something. I just had in my notes that when I talked to Attorney General Ellison, I said, well, don't hurry back. You're fine. You got Wonka. I wanted the person that wrote the actual bill here, right? It's kind of like you actually write your own bills, right? There are some people who don't actually write their own bills. They use people like Sam and Bryce and, to write that in the revisor. So I wanted to make sure Mr. Wonka, who was the author of this, because if we were going to get into a contextual debate on, and I still have 6 points that's going to take us past 11 o'clock that I wanted, he needs to answer, or I ain't going to support this bill. I mean, that's the thing, right? So I told the General Ellison, I just said, no, I really don't hurry, rush back here. We're okay. So are you okay? If not, I'll reset another meeting with him if you want, but I think we're good.
Thank you, Mr. Chair. I would appreciate having the Attorney General here today, because I read in the newspaper that this is a big priority for him, and so I would have thought he would have made time to come here and answer questions from the committee here today.
It's on me.
I guess, one question I had that maybe the staff from the Office of the Attorney General can answer: how many attorneys work, or how many people work for the Attorney General's office?
Mr. Wonka, Mr. Wonka, do you know off the hand?
Senator Hoffman, Senator Rasmussen.
That's Chair Hoffman.
Chair Hoffman, I apologize. Got the process wrong. Chair Hoffman, Senator Rasmussen. I believe that it's over 300, but I don't have an exact number for you.
That sounds about right, Jordan, I think, yeah.
Thank you, Mr. Chair, and thank you, Mr. Wonka. And I know the Attorney General's office is busy suing Menards over their rebates and having joining lots of multi-state litigation and putting out press releases, but why can't the Attorney General's office within those 300 people reassign or find room to prioritize anti-fraud work, given that we're facing a fraud crisis here in Minnesota? Why do you need to have just more money, more attorneys?
How did you do that? That's a good point. How did you do that, Mr. Wonka, within your department? As all this was, going, the different tensions from all different parts of, because you oversee, I didn't realize you had somebody within that was a DNR expert, right? I mean, how did you read, to Senator Rasmussen's point, how did you reassign, and what does that look like?
Chair Hoffman, Senator Rasmussen. So I can only speak to the Medicaid fraud unit because that's the division that I supervise.
I think that's what you wanted, right, Jordan?
Right.
Yeah.
Yeah.
Yep.
So we have 32 people. and that budget's set by the federal government. To get more people to work in the Medicaid fraud division, we need to have state matching funds. We need to have approval from the federal government to expand. This recommendation that we expand is based on the increasing size of our Medicaid budget since 2019 and the increasing number of referrals. And so we can't just take somebody from another division, have them work for us for 2 weeks, and then go back to what they're doing and be eligible for matching funds from the federal government. The regulations require these to be, quote, clearly identifiable personnel costs, and that's going to be a long-running permanent position. That's not, we're going to get somebody in here for 6 weeks to try a case, and then they're going to go back to what they're doing. There's also an expertise gap in the sense that these Medicaid fraud prosecutions are very complicated, right? Like we've talked a little bit today about how complex the system is. Having somebody who's never worked Medicaid fraud come in and moonlight for a month or two is not going to be an effective way of operating. We need to have people who have the time to be trained, to be onboarded, and to get familiar with the program and how it's supposed to work so that they know what's going on is actually not allowed. This is a complex system, and it's not just as easy as taking somebody who's never worked in this space and saying, hey, here's a stack of Medicaid fraud prosecutions, go try the case. That's how we end up with actually very bad results when you have people who do not have the expertise in this area and are trying to cover it.
Jordan. Senator Rasmussen.
Thank you, Mr. Chair. And again, it sounds like about 10% of the people who work in the Attorney General's office are focused on this Medicaid fraud, even though I think it should be the #1 priority of the office. And I didn't hear any explanation for why the Attorney General couldn't reprioritize resources within his very large budget and say, this is a priority for the state of Minnesota to go after Medicaid fraud. I'm going to use some of my budget instead of suing Menards and going after, joining 30 state lawsuits that really doesn't matter whether or not there's a brief from the Minnesota Attorney General's office, and actually prioritize going after fraud. I don't think there's anything that would prevent the Attorney General from doing that and reassign those resources unless I'm missing something. I don't know why the Attorney General couldn't do that.
That's a systems question, right? It's like how, because, to hear Mr. Wonka explain, it is complex, right? So, I'm glad he explained, how they did it, but it needs to go deeper. Senator Rasmussen.
Thank you, Mr. Chair. And the other point I'd make here is that I think, and Senator Abler talked about this, if this was, overall, if you read the text of this bill, I don't really have problems with it, right? And I think we should be prioritizing going after Medicaid fraud. However, the people that I represent, there's a lack of confidence in this Attorney General's ability to go after fraud. And you don't have to take my word for it. You don't have to, go read any partisan talking points. I'm just going to read from the Minnesota Star Tribune here on, I think, one of the biggest misses that this Attorney General had.
I got you. You're getting payola from Menards. You're getting payola from the Star Tribune now. So I'm kidding.
I want to.
I'm trying to be funny here. You cite your source, and then Senator Fata has a point. He has a question as a follow-up to your point that you're talking about. But go ahead and
so
do
if
your
we look
cite.
at the Feeding Our Future scandal, where we had $250 million stolen from taxpayers, I just wanted to read from an article from 2022 on the Star Tribune, and they said, I'm just quoting here, a Star Tribune review of state and federal records shows that Minnesota officials provided federal authorities with little or no evidence that Feeding Our Future was misappropriating government funds. The FBI had to build a case from scratch. And they go down to say later on, the Attorney General's office has broad authority to conduct civil fraud investigations and could have initiated its own probe or demanded the nonprofit's bank records before the feds stepped in. And Ellison's office began representing the Education Department in court when Feeding Our Future sued the department in November of 2020 for blocking its expansion plans. If Ellison's office had used its investigative power to pull bank records, it could have found that alleged conspirators paid at least $524,000 in bribes and laundered $3.2 million in program funds between July 2020 and March 2021. And so, Mr. Chair, that's where the opposition to just giving the Attorney General more money comes from, is that in the past, he has either been unwilling or unable to go after obvious fraud and to work with federal partners to protect Minnesota taxpayer money. And even when he, as the attorney for the Minnesota Department of Education, went to court, they weren't able to stop funding that going to Feeding Our Future, and they were unable to successfully make that case, even though it was the most brazen fraud that we saw in the country during Feeding Our Future. And so that's the concern here, and that's why I wish we would have had the Attorney General here today to answer to these questions that I get from our constituents about why
and I'm glad, and that's
that
another,
office hasn't been going after
and
fraud.
thank you for that, but I want to, it's interrelated to this bill, right? That I just want to say to us, I really want to stick to the fact that by having that conversation, and Senator Fata wants to add to your point, but it almost like I want to make some assurances here in the 6. I still want to get my 6 questions. I'm letting everybody else go. And then now it's time for me pretty dang soon because, last time I looked, I got the gavel.
Hey, Mr. Chair?
Yeah, well, you have to wait.
Yeah, I know I do. But there's another senator that agrees with me, by the way.
Oh, God. Senator.
Before you know it, I'll have a majority.
No, I am glad you bring that up because, it's all interrelated, Jordan, and I do hear you on that. I really do. But I just said but I want to stay focused on the fact that I have some deep concerns about this bill, right? I really, really do. And he needs to give me assurances or he's not getting my vote on this bill. And I said that to him in the hallway. I said that to to General Ellison as well, right? And I'm hearing all the conversation, and yes, contextually, I've said it now 4 times, the argument's there. But, negate everything I said before that. I need to have assurances that people with disabilities are not the fodder in this conversation. To Glenn's point, when he brings up the $500 million, he only cares about the fact that $500 million means those folks not receiving services. And in like little town of Arlington, where they had 2 nursing homes shut their doors, I think one was assisted living, but the fact is they shut their doors. So that's all I'm saying. And I appreciate you bringing everything up. So can we go to Fatah to ask? He looks like he wants to talk to you anyway, I think, Jordan. Go ahead, Senator Fatah. Oh, finish your point, Jordan. Yeah.
Yes, yeah, Mr. Chair, I direct this to the director. I mean, do you think Minnesota has a fraud problem, and do you think that the Attorney General's office has done a good job pursuing fraud to the fullest extent of the law possible?
That's an honest question, Mr. Wong.
Chair Hoffman, Senator Rasmussen, I think every state has a Medicaid fraud problem in the sense that that's why every state has a Medicaid fraud control unit within it. We've seen this as a national problem. It's not solely restricted to Minnesota. As far as whether we have done a good job, I would rely on the federal government's audit of us, which found that we had the most fraud convictions from 2020 to 2022, which is before this crisis hit national news. That is a source that is based on objective numbers. And since then, as I indicated in my testimony, we have been near the top of the nation in the fraud charges and the fraud convictions that we have obtained through our Medicaid fraud unit. And I think what those numbers illustrate is that this is a problem, that this program integrity issue that cannot be solved solely with criminal prosecutions. There are a number of different things that we have to do to ensure program integrity on the front end that we're not going to be able to solely address through prosecutions, which are a necessary part of this overall picture, which is why we're all here talking about it today. But that would be my response, would be to rely on the numbers, rely on the results of our Medicaid fraud unit, and the work that we have done over the years.
Thank you, Mr. Wonka. Senator Rasmussen.
Thank you, Mr. Chair. And I guess it's disappointing that we can't get a recognition that we have a fraud problem. And whether it's from the leadership of the Department of Human Services or Attorney General Keith Ellison's office, they can't say that Minnesota had a fraud problem. Okay. That's what Andy Lugar said years ago, that Minnesota had a fraud problem, and for us to fix it, we have to recognize that we have one. And I would say just because we have more fraud cases here in Minnesota is not a sign of success. I think we have seen many high-profile cases, including Feeding Our Future, where Minnesota had the worst fraud in the country, and we have to recognize that fact.
Okay.
We're going to try to address
now
it.
Now I'm going to say, can I get back to this? Seriously. I'm not going to you. I'm going to Senator Abler.
Well, thanks.
No,
I
I'm not
actually
going to
have
go
a-
to you because of follow-up. I like where Senator Rasmussen's going, but Senator Abler was ahead of you. And if you're going to build, and no disappointment, I really seriously have concerns about this bill. We need to address those concerns. To Glenn Gruenhagen's point, the $500 million assurances, I need some assurance 3 times, Glenn. Go ahead, Senator Abler.
And actually, I'm going to ask a question relative to that. I just want to offer a comment. I think just on this whole rhetoric thing,
Yep.
you and I, and we sat in a room somewhere and came up with like 10 things you could do to rescue the housing stabilization program.
Oh, yeah.
Which,
Last year.
and there were very legitimate providers there providing legitimate services. There were a bunch of people who were just horrible that were stealing from it.
Yep.
But if the department could have put those into place, there would have been de minimis issues.
Yep.
And instead, it just, I don't know why the governor had to ask CMS to say, could you please cancel this program for us? We just can't handle it. I think that was really a bad idea. And it got the whole tone going, and I don't know who's recriminating against who.
Yep.
But it didn't help. And there were good providers who served legitimate people who were not getting services now over that. I just wanted to offer that. So my question that I think is on your mind, Senator Hoffman, so I told my Mr. Clark a month ago that there's 540 cases referred to you. You said last time there's a couple hundred being investigated. When you decline, can you just explain, you get a case in and you go like, there's not enough there for us to mess with it. What happens to that provider? And are they done then? Do they go back under a watch? And part of my question is, maybe they're a dolphin and they just had some smoke and suspicion and DISHA level, which is de minimis. So how do you kick out the ones that you think are insignificant? That's my question.
Yeah, I think that in Senator Abler, it's like, I think the department gave us like out of they have 3,000 things, 500 of them are sent to law enforcement,
Yeah.
and that would be the law enforcement person right there. So yeah, to that point, Mr. Wonka.
Chair Hoffman, Senator Abler, so our process goes, we get a referral from DHS, we look at it, we decide, is this criminal fraud, right? Is there intent to defraud in here? Or is this simply some, administrative error, timesheets missing, certain information, something like that? If we decline the case, we provide DHS or the MCO or the referring entity with a form that I sign that says we are declining this case. We are not accepting it for investigation. At that point, DHS has to make the determination of whether they're going to continue to withhold payments for some other reason that is unrelated to us, or whether they're going to put them back on. And within the federal regulations, they have the authority, certainly when we decline it, to turn payments back on. They have the authority to continue paying while they refer it over to us. I mean, there is something in there that says they have good cause to not suspend payments under certain circumstances. And we don't ask them to suspend payments at any point. We don't say, like, we're accepting this, now you have to suspend payments if you haven't. That is solely their decision. They have different considerations. We are not involved in that. We're not asking to be involved in that. And so we stay out of it. But what we do is we clearly notify them, we are not accepting this case for investigation. So this is on them at that point.
So, Mr. Chair, and so that's the dolphin part we're talking about. And so we want to get after the people with the ill intent that know that they were doing something wrong and they were trying to get something that wasn't coming. And we all more than unanimously agree that that's what we're after. And so we're working on some of that process in 4222, but there just seems to be with the rhetoric, which is going to be throughout until November, legitimately.
You should have given us 3 hours because I knew that it was going to.
Yeah, but anyway, I just hope there's a way that we can keep this in the realm of good policy and just, beat the heck out of the fraudsters and, let the dolphins go. Thank you.
Senator Fatsa, I moved you two, I was moving you two up and down the ladder so I just went, Senator Fatsa wanted to bring us back to that conversation, Senator Abler. So Senator Fatsa.
No, thank you, thank you, Chair Hoffman, and I wanted to just tie it back to the budget, a couple of things that were said. The Mufuku office, or the Medicaid Fraud Control Unit office, The staffing levels were determined based off of the size of the Medicaid budget. In the past, when it was $13 billion, now it's $20 billion. That's why the staffing level is at 32. And if you look at other states with similar Medicaid budgets, the $20-ish billion range, you see that Washington State, for example, has 57 staff, Indiana has 59, Virginia has 92. And so if we're talking about, you and I share the same concerns about we need to center this around the folks that needed the services that didn't get it. If we, like you said again, if we don't politicize this, and as Senator Abler said, just think about it as like a generic attorney general in that office, they need the staff. And this is important work. And this is not an expense, it's an investment because of the amount of money they bring back in and they recover. And they're going after people, charging, convicting, making sure that they're held accountable and bringing money back in. I think that's how we need to center the conversation rather than politicizing it.
Thank you for refocusing. That's exactly, and that's always a challenge. I mean, I hear that, and I could feel that piece of it. There's a part of that. So I thank you and Senator Abler for that. And I do, Senator Rasmussen, Senator, everybody, I appreciate the conversations. I do. This is it. Absolutely, I do. So thank you, Senator Fonson, for bringing it back. When you have expansion of fraud that becomes now a theft status, right? I'm coming to come to you, Mr. Wonka. The Medicaid billing issues are explicitly tied into theft and fraud law. And so my concern is, and you have to do this, you have a shift. You have a shift from a administrative compliance to now into a criminal framing. Public Law 99-457, when we went from Part H to Part C, Senator Abler, I talk about that all the time. There was the root of Part H was based in compliance, right? Part C became technical assistance. So there was a shift in how you went into local school districts, local area agencies, and provided, were you compliant? Was it compliance-based or was it technical assistance-based? Now, you have an administrative compliance issue shift to now criminal framing. There's a high need, the high need clients, there's more complex billing. And again, it's gonna come to you assuring devolution of information down so that it doesn't become just criminal framing. So people with the most complex disabilities could face reduced access to providers that are willing to serve them. There's gonna be there's gonna be a provider adverse piece in here. I'm gonna just tell you that, so it's gonna happen. Based upon just the paradigm shift in culture. What are you gonna do to ramp that up and to assure that the people that have the most complex care needs are not being left out in the cold?
Senator Hoffman, so we are not interested in enacting laws that are going to impair people's access to care. That is not the intention of this, and this is based on some of our conversations between last session and this session with the provider networks, where they raised concerns to us about the ways that we drafted statutes last year that did not include those terms, intent to defraud, in there. We added that this year to this piece. And what that means, and from the legal perspective, but it's important to just cover that before I get into how we're going to talk.
What's the Latin phrase, mens rea?
Mens rea, yes, the mens rea, the mental state. What that means is that we have to prove beyond a reasonable doubt at the time the defendant's conduct occurred. So not some guidance given 2 years after or 1 year after by the department. At the time the defendant's conduct occurred, the defendant knew the claim for reimbursement that they're submitting is false or ineligible for payment, that they intentionally submitted it to get the payment anyway, and that they took all of those actions with the intent to defraud DHS into paying them for the money. And so what that doesn't allow is it doesn't allow us to charge a case where there's some kind of ambiguous policy language, where there's no policy guidance whatsoever given, because a defendant, when policy guidance is unclear or there's nothing covering it, a defendant cannot know that it's disallowed at the time that they're doing it. And so that's why we included this intent to defraud language in here, to make sure that we are not catching people, particularly in a complex care need, right? Like, we're talking about billing for services based on whether it's unit-based billing or daily rates. We're talking about billing for services in pretty specifically delineated limits and only for services rendered. And we want to ensure that everybody's getting that, but when you have the provider who's not sending out anybody at all, right? We know that services aren't being provided to this person based on the evidence in our investigation, that this statute can capture that.
So let me follow up with that. Burden of proof falls on who in that? So if I have something that is relevant, you use the term relevance to an investigation in your language, right? The guardrails beyond just relevance to an investigation. Who has the burden of proof in that case that says, well, actually it was a clerical error and you know, mea culpa, right? And legitimately, that does happen sometimes, right? Who's the burden of proof fall on in an appeal?
In the criminal, Senator Hoffman, in the criminal case, the burden of proof is on the state. It is our burden to prove beyond a reasonable doubt.
So hold this back. So the state burden of proof. So if I feel like you're looking at my paperwork differently than somebody else would have, like a technical assistance or a compliance issue, and you're looking at it now, are you catching with me where my concern is? The burden of proof falls on you to prove that that's a criminal act, correct?
Correct.
All right. Then you've answered that gap, because that was a gap that's not very well defined, unless you're a lawyer and you understand the language that's in there. I needed to hear that from you, and now it's on public record, which is good. There's because people with disabilities rely on, and I'm going to share three things: the caregivers, shared finances, and there's a third-party service coordination, right? This happens all the time, by the way, in this committee. It doesn't bother me. There's sidebar conversations. It is what it is. There's a risk that when you overreach into the personal lives of the individuals with disabilities and their families that are navigating a complex, I'm going to say this again, complex care system, we have some concerns there. I need you to assure me that you are going to look at fixing that gap.
Senator Hoffman, as I've said, we do not want people to go without care. We are always willing to listen to providers who maybe we open an investigation on and who come to us and say, look, we know you got this referral. We know this is what the Department of Human Services found, but we think they got it wrong. And here's our evidence. We have those conversations with lawyers for the providers or with the providers themselves when they're unrepresented, where they can send us these documents, we can look at them, and this can all occur, you know, hopefully before this case even gets into a court system.
So I'm gonna go to Senator Fatah, but before I do that, there's my concern when you look at the knowing or having reason to know standard, which you and I talked about in the hallway, right? There's fraud includes claims where a person knows or has reason to know something is false, right? We know that that's false, therefore it's fraud. That's that's a subjective legal threshold. How are you going to assure that you don't have case manager A and case manager B and people over here making different decisions? Because believe it or not, if you look at the different departments dealing in human services and people, there's different opinions from individuals given the same question that goes. There's that lower, more subjective legal threshold. There could be a misunderstanding, or there's an administrative mistake, or there's errors that's in there, right? And that is going to be in the notorious complex Medicaid billing of waiver services, self-directed care, and the PCA services. I have those gaps still are sitting in front of me, and so I need you to just be very clear about how you're going to get that. That is not a criminal liability. And I think you answered that by saying the burden of proof falls on you, the state, as intent. If the mens rea is X, then it's going to be criminal.
Mr. Chair?
Yeah.
I just was looking at my watch.
I don't care.
No, but we can't meet when Senate's in session, but I'm happy to come back.
You guys asked all the questions earlier.
No, I think we should come back and finish this discussion.
No, I think
it's that important.
I think we're good. It's really important to me, but I will get it offline because I will have the floor. We did the refer to judiciary. I'm okay with that because that will.
Well, I'm just saying I'm ready. I would be willing to flesh this. I mean, just if you want. I can vote, or I just.
No, you know what, I'm fine. We can, because we got to get to the floor.
I'm not trying to terminate you, Mr. Chair.
So, no, you're fine.
But, Mr. Chair, so we need to make sure that those concerns are figured out, and maybe this is where that has to happen. Or if they're going to go figure it out on judiciary, and you can go there and express your concerns. But this reason to know thing, I just, like, oh, you should have known. I'm a guy, 44 years being married. There's a lot of things I should have known, Mr. Chair, that it seemed like a good idea at the time.
No, that's funny, Omar. So I didn't realize.
And I was guilty.
I had 6 points I wanted to get across to him. I got 2. I'm good. I take it, I'm going to go to judiciary with these questions. I'm going to make sure they're there. So I didn't realize the time. And thank you, everybody, for participating. Senator Omar, you're good with that? Senator Fateh moves that Senate File 2689 as amended be recommended to pass and re-referred to Judiciary Committee. All those in favor say aye. Aye. Pose same sign. You're on your way to Judiciary. Fix that language. And all those points that I gave those to General Ellison, if you want me on the floor to say yay, I got to have assurances.
Mr. Chair.
Happy to talk about it. Let's, we'll
Thanks,
set up
Mr.
some
Wong.
time. Thank you.
Just to one more point.
We are adjourned, by the way.
Oh, did
Go
you
ahead.
adjourn?
No.
Oh,
What?
we're just about adjourned.
Yeah, you want to adjourn?
You voted. I just want to comment. So they said, we don't think there's anything you did wrong. So we just want to follow up to make sure the OIG goes like, oh, I get that. And so so that's not the question for these guys, but it's
No.
an important question.
No, that's-
And when they decline, there's no criminal fraud, they say.
Yes.
Okay, then where do we go next? That's our next work. Thank you.
I think that's our work at this committee, so thank you for bringing that up. Thank you. Thank you. We are adjourned.